Hello, good morning to colleagues and clients and fellow participants. Welcome to a 2022 where we're starting off with no wave. We hopefully have passed we have officially been out of the fourth wave of COVID-19. People are returning to the offices. Traffic has been backed up. We now are plagued with normal things like load shedding and the like. My colleagues today will be taking you down memory lane as we reflect on what had transpired in the year 2021 and what lessons we can glean from there in 2022. They'll also speak to you about what legal challenges you are going to foresee during 2022, and the hot topics at the moment are a mandatory vaccination. Our firm was honored to have advised Gold Rush in its leading up and its implementation of the mandatory vaccination, which is one of the first cases issued by the CCMA relating to the termination of an employee who refused to take a vaccine. Obviously, the CCMA decisions are not binding. To Karushka and the marketing department, thank you for arranging this, and they will be sending to you a judgment, hot off the press, issued yesterday by the Labour Court, where Solidarity had sought to challenge the implementation of a mandatory vaccination policy on an urgent basis. The court struck the matter off the roll for want of urgency. So the court did not make a decision on the merits of the matter, but rather struck it off as a matter of urgency. And we're able to bring these cases to you, as you can see from our alerts and media publications, as soon as they are available, and that we intend to ensure that you are kept up to date and have the information as soon as possible so that you are able to adequately determine how best to deal with your business. Moving on to our next topic, the President has sent it to three pieces of legislation dealing with GBV, and we will, in the fullness of time, be publishing a document and an article relating to the interplay between these pieces of legislation and employment law, and ask that you keep a lookout for it. As we move and navigate 2022, our emphasis is going to be ensuring that you are empowered through the information that we provide to you. Through our professional services lawyers, Amy King and Riola Koch, we are going to be introducing more e-learning modules so that you can empower your employees and yourselves to keep abreast with the latest legal developments. Finally, before I end, may I request that you complete the poll which our marketing department and Amy King will be issuing, getting your feedback as to whether you are ready to hold in-person webinars and seminars, or do you prefer this medium for us to relay information to you? We have found that this is an effective way so that people do not need to battle with traffic and are able to do these seminars and webinars in the comfort of their offices and their homes. But we do understand that you really do miss engaging with us and our scrumptious breakfast that we have, and we'll take guidance from you. Please enjoy the seminar. I now hand over to my colleague Imran Mohammed, who will be facilitating this seminar reflecting on 2021 and navigating 2022. Thank you all.
Thank you, Adil. Good morning, everybody. In early 2020, I think it would have been rather difficult for us to imagine how much would happen over the period of the pandemic. We all know its ravages. We know its personal ravages on individuals. We know what it's done professionally. So I don't need to report on that. We know that in the UK, in France, in Denmark, there's already a shift to relax lockdown restrictions. So the Europeans are throwing away their face masks. They're allowing better human social interaction, which is desperately needed, as we know, over the last 2 years. And in some quarters, there's a cautious return back to office, and I dare say reluctance on the part of employees to return back to the office. But the reality remains that we continue to live through a pandemic, and that's the reality of our current situation. In South Africa, by March of 2022, we'll be heading towards 730 days of the lockdown, and that is significant. None of us in all of our lives have ever experienced anything of the sort, but we have learned over the last 2 years how to regulate ourselves, how to regulate businesses, and how the human resilience needs to get back onto track so that we can continue with our lives. So what we intend to do is to cast our minds back. That whilst in 2020, in the beginning stages of 2020, after the initial lockdown, we explored extraordinary questions for businesses, for labor lawyers, for tax lawyers, for insurance lawyers, questions relating to the payment of salaries to employees during a hard lockdown. How is it to be managed? What was the laws around that? Determination of retirement fund rule amendments, questions relating to TERS, the tax implications relating to TERS. Was it salary? Was it benefits? What was it? The topics were endless. They never stopped. I could almost probably do a TikTok. No, I couldn't do a TikTok. My daughter could, on how lawyers had to answer questions in the beginning stages of the lockdown. And almost every answer was, I don't know. I don't know, because we actually didn't know, because there were no laws and we actually needed to find our feet in order to advise. And so it was so difficult for managers to run businesses as well. Fast forward to January of 2021. By then, we started exploring and debating the questions around mandatory vaccine policies. And I'm pleased to say that now in 2022, in the third year of this pandemic, we're able to focus a conversation with yourselves on somewhat more positive aspects, if there can be anything positive relating to COVID in the workplace. So with that having been said, it's a pleasure to introduce our panel that's going to look at these particular topics. We've got one employment lawyer, Hodisho Pashe, who's joining the panel, a legal tax specialist, Humaira Parak, and a TMT lawyer, Apandile Govuza, who is going to delve into these topics with us. So, Hodisho, only because you're a labor lawyer and I've got a bias towards employment law, and because this has been facilitated by me as a labor lawyer, we obviously were strategic about this year. If it comes to a vote on anything, we vote together. So let's jump into it on an employment topic. If we reflect on 2021, the Disaster Management Act, there were numerous regulations that were issued over the period of the lockdown that related specifically to the workplace. Before we jump and get into the hot topic about mandatory vaccine policies, perhaps if you can just have an initial conversation with us in relation to what sort of disputes had come before the CCMA and various bargaining councils across the country, and the nature of forms of disputes that employees were facing in their workplaces and had to be determined by arbitrators.
Thank you, Imran. And once again, morning to all of our clients, colleagues, and attendees. Yeah, Imran, that's actually a good question. And as you've been saying, obviously, with something as unprecedented as COVID-19, we started seeing new trends in cases that were being referred to the CCMA and the relevant bargaining councils. And having reviewed the COVID-19 disputes in the past 2 years, I'd say that there were 3 predominant grounds for dismissal. And these grounds were mainly related to COVID, and they had to do with absenteeism, insubordination, and obviously the hot topic of them all being the breach of COVID-19 protocols. And those were basically the most predominant grounds.
So keep me honest on this one, Khadisha. On breach of COVID protocols, it appears that the CCMA adopted a zero tolerance streak. An employee breached COVID regulations when it came to an employer's workplace. That was the end of it. No first warning, no second warning, no progressive discipline. You got the axe.
Yeah, no, definitely.
Would that be a fair assessment?
Yeah, no, definitely that. The CCMA actually took a strong stance in that regard, because as its main objective really is to ensure that there is fairness for both employers and employees. The CCMA actually looked at what rules were actually there, and they looked at whether the rules were reasonable and whether the employees were aware of such rules and whether the rules were consistently applied, and if dismissal was an appropriate sanction. And to be honest with you, in an instance where we have a pandemic and we have individuals, or rather employees, who fail to follow the necessary protocols, the CCMA had to take a strong stance against it. And Imran, something as interesting as having a case, like for instance the popular case of Scosanan and Total, where a petrol attendant was dismissed for failure to wear a mask. And in essence, it's one of those things that we always go back to: was the rule reasonable? Right? And the CCMA looks at that as, yes, the rule is reasonable because we're going through a pandemic. So that is one of the examples of matters where the CCMA blatantly expressed that it would not condone any sort of recklessness in the workplace.
And then perhaps before we get to the topic of mandatory vaccines, let's just touch on absenteeism. I mean, as recent as I think it was Monday, that government issued a new change in relation to the isolation periods. There's obviously a possibility that employees may now self-quarantine, isolate themselves in accordance with what the laws were prior to the amendments of last week. Any tips for employers relating to that aspect and what arises from case law over the last 2 years, and particularly last year on absenteeism?
Yeah, no, thanks for that. And I think that's a very important change that employers should know and notify the employees. So our government has issued new regulations in terms of isolation and has decreased the period of isolation from 10 days to 7 days. Now, that's a drastic change for employers if you actually think about it, because now if your employees are not aware of such a thing and they either test positive or they are exposed to someone, they need to know that the isolation period is 7 days. And again, going back to, is the rule known or is the rule reasonable? Was the employees aware? This is also something that employers must take upon themselves to notify the employees, because it's going to come back and we need to say that, no, we actually did communicate this. And it's very interesting how absenteeism during COVID was such a hot topic, as we've seen in case law that employees would just not come to work, and there was various reasons. Some of the reasons where employees were just afraid of COVID-19, as we all were in the beginning. We did not know what it was, how it affects you, and how it may affect you and your family. So, but then on the other hand, we had borderline cases and cases on the other side where employees were just being unreasonable. As a startup, in the case of Beck and Palmer, this is an important one. An employee was dismissed for failure to come to work for 21 days. Now, take into consideration, this was during the Log 5 lockdown. Right? The employee had requested leave, even unpaid leave from the employer, because she feared to infect her family. And she mentioned, she brought up grounds that she had vulnerable family members and children with asthma. And although the employer at the time had 16 other employees, it refused to consider the applicant's individual circumstances. Now, again, this was level lockdown 5, right? When everyone did not know. Now, the commissioner deplored this approach and found that the dismissal was unfair as the employer's requirements were unreasonable. So again, the CCMA does want employers to at least attempt to see how we can accommodate our employees. Now, on the other hand, we have the case of Scosanan and Eros mining, where the applicant in this instance was way less fortunate than the previous one. He was a miner, and along with several others, were sent home to isolate after a colleague had tested positive for COVID-19. Now, the manager told them to go home and isolate, and thereafter, after 10 days, they should return. After the 10 days, the manager telephoned the employee, and the employee said he was not feeling well. The employee was requested to take a COVID test. He failed to do so and still did not come back to work. So now there you see how he refused to take the COVID-19 test and still refused to come back to work. That's a clear case of absenteeism, and the commission resolved that the dismissal had been fair, as it was improbable that the applicant did not know that he had to come back to work after 10 days. So those are the
sorry, I guess the takeaway point from that is what the earlier point that you were making. Ensure that the rule is known to employees. So even with the change in the law in the last week, it's important or imperative that companies make the new law known to employees and what the position is, so that there's no confusion and the employee can't rely upon that in order to avoid any liability if an issue arises. I guess that becomes the takeaway point.
Yeah, no, definitely correct, and that's what the code of conduct of the CCMA really even encourages, that you make the rule known, make it reasonable. Yeah.
Obviously. So then let's get onto the hot topic. So as I was driving into the office today, 94.7, that very rarely ever talks about anything serious on the breakfast show, because one would expect some casual conversation in the morning, was having a debate about mandatory vaccines. So I mean, I thought, let's listen to this. It's very interesting. So let's frame this conversation correctly. In January or February of last year, when we had this discussion on this platform, I remember the debate we were having, because there was no law around it. So we were saying, well, if the law was to be, where would it likely go? But in the instance where we don't have a law on a mandatory vaccine, what is our views in relation to how to manage it, with reference to constitutional provisions, etc., etc. But come June of last year, with the consolidated directives that were issued, we now have a law under the Disaster Management Act by way of the regulations, where the Minister of Employment and Labour says, well, within your own workplace, you're entitled to have a mandatory vaccine policy. So we all know that anybody that enters this debate must have a mandatory vaccine policy. In the absence of that, there's no conversation. We know that the two bases under the directive that allows for exemptions. We know them. The one is religious, the other is medical incapacity. We don't need to get into the detail around it. We've discussed it. The law is reasonably clear in relation to that. But what employers are currently beginning to see, Khudisho, let's have a discussion around those issues. Employees who are saying, well, I can't make out a case in respect of the exemption for religious reason, or I don't have a medical justification not to be vaccinated. What are the forms of debates or objections that employees are now raising that you're coming across?
Yeah, thanks for that, Imran. So what we're looking at now is we're looking at a space where we don't have any laws yet, and there isn't really much to lean back on. Now, some of the grounds that we see in our employment spaces and our case law that's coming out through the CCMA is that employees are really looking at their right to bodily integrity, and which again, they're looking at the Constitution and just are trying to work out how do mandatory vaccination balance, or how are they limited, or how can the Constitution limit those? So we're seeing a lot of those where they're claiming the right to freedom and relying on the Constitution. And on the other hand, you said there's also religious exemptions where we have employees who come and say that their religion or whatever belief they subscribe to does not allow for vaccinations, and because it hasn't been tested, which for the few cases we have in the CCMA, the employees really struggle to bring up any evidence of the religious exemption and whether there's any Scientology or theological basis of such an exemption. So we're looking at those aspects now, which are a bit difficult to really maneuver.
So I've come across a number of objections by employees simply on the basis that, well, because there's no general law of application on mandatory vaccine, that, well, it's my choice. And for an employer that has a policy in place, well, then there's some difficulty with that argument, because if you start out the argument on the premise, my body, my choice, your employer takes the position, it's my business, my rules. So the policy is the starting point. In the absence of a policy, any employer would have difficulty in relation to rolling out a mandatory vaccine policy. So that's the one aspect of it. So I'm finding that argument arising quite often. And the other, where employees are saying, well, this is an experimental drug. Whether it's the vaccine that comes through Johnson & Johnson, whether it's a vaccine that comes through Pfizer, whether it's a vaccine that comes from Sputnik or wherever else, it's all experimental. Therefore, I refuse to be vaccinated. And that too, there's limitations to that argument. So we've come across a number of organizations that are kind of pushing an I'm hesitant to call it an anti-vax approach in the context of COVID, but let's call it that for want of a better term. But there are a number of organizations that are doing that. Just talk us through some of them that you've come across.
Yeah. So and what you're mentioning is indeed very, very serious, Imran, because one thing that I will say, and I strongly agree with what you're saying, that if you do not have a mandatory vaccination policy, which was implemented through a risk assessment, then there shouldn't even be a consideration of getting your employees to vaccinate or forcing them to vaccinate. So that's where it starts. And I think a very important thing that we see in our consolidated directive is that it's very clear in that every employer must undertake a risk assessment, and taking into account the operational requirements of the workplace, then it must decide if it intends to implement that. So that's just the point of departure with that. Now, as for the organizations which are really seeking to not have either their members or employees vaccinated, we've seen a lot. And at the forefront, as an employment lawyer, I'll tell you that trade unions are on the forefront of this, as their natural mandate is to protect the employment security of their members. And when it comes to COVID-related dismissals, we see COSATU, FEDUSA, and NACTU, who are very vocal about job losses. And however, as Ado mentioned in the beginning, Solidarity has been the most active trade union in the courts in this regard, as there's currently an application before the High Court in the Free State, and the application is basically challenging the implementation of a mandatory vaccination policy at the University of the Free State, and there's multiple factors to which they object to. A few being that a risk assessment was not successfully undertaken, no vulnerable employees were identified. They basically challenge that the assessment has been generalized, that there's no details in terms of how the policy will achieve the objectives. So those are the organizations we're seeing, and some others being Pandemic Data Analytics. The HBR Foundation has been one of them, which represents those who's been dismissed for refusing to be vaccinated. So we are not short of organizations or people on the other side that are fighting for vaccines not to be mandated.
Yeah. So I guess the point at the bottom of it, and probably well made in relation to the Solidarity and University of Free State case that you're referring to, is an attack on the policy. So it gets back to the initial point. If an employer doesn't have a mandatory vaccine policy in place, well, there's no discussion, and that's where it kind of starts and ends. So in order to get into the debate, you need the mandatory vaccine policy, and then to allow the process to unfold from there. So let's Horisho, pivot away from that. Humaira, you know, the old adage that whilst the world changes, there's two constants, and the one is tax and the other one is death, was very true in the beginning of 2020 with this pandemic. So whilst we were all over the show trying to work out what the world was saying, the one thing that was certain was that we were going to pay taxes. Let's turn to a discussion around this concept of remote working. The forcing workers into a remote environment and allowing a large portion, or at least a segment of the workforce, to work from a remote location, like from your home, has kind of had some benefits for individual taxpayers. So what are the considerations which employers, you would say, ought to bear in mind in respect of employees who work remotely?
So Imran, there's nothing really that an employer has to do. So an employer must simply continue to adhere to its employees' withholding tax duties as it would have in the ordinary course. What happened over the past 2 years is a lot of attention was drawn to the question of whether employees were capable of claiming a deduction of expenses that they were incurring from now working from home. And so, you know, the Income Tax Act provides that, you know, the in principle position is that employees are entirely precluded from claiming any deduction that relates to employment from their income. So that's the general position. There is, however, an exception to this, and that's based on the duration of time that an employee spends outside of the office. So, you know, just in essence, what the exemption provides is that if employees have a home office that is fully equipped with everything that they need in order for them to perform their functions at the office, and that home office is regularly and exclusively used for purposes of their employment, they could be eligible to claim a deduction, provided that where they are normal employees, just simply either remuneration or director's fees, they spend more than 50% of their working time in a particular year of assessment working from that home office, or if they earn the majority of their income, which is more than 50% of the income, from a commission-based, either commission-based or performance-based income, then they need to spend more than 50% of the year of assessment. Their working time needs to be anywhere outside of the office. But again, just to go back to your question, that really has nothing to do with the employer. It's really for the employee to claim the deduction in their personal income tax return. And the most that an employer can do is educate their employees. It does make for happier employees if they are able to claim a refund from SARS. Employees generally, unlike juristic entities, we have very limited scope to try and reduce our taxable income. It's simply deducted from our salaries. Employees could potentially provide staff with a letter confirming the duration that they work from home, because that is one of the documentation that's requested by SARS. And then I think the third thing, and this is, actually a request by SARS, because SARS has over the past 2 years been very conscious of the fact that there could be a substantial loss to the fiscus if a lot of employees claim a deduction. And so they've published a lot of media statements, etc., to this effect. But one of the things that they've said is that these expenses really must relate to the construct of the home office, and not be, for example, data, stationery, cleaning, and all of that. That should rather be reimbursed by the employer, and then the employer claim the deduction. And from a deductibility perspective for employer, it's far more likely that they'd be able to achieve it. So entirely discretionary at the instance of the employer, but those are the three inputs that they could give.
Okay, so effectively it's quite nuanced, and it really boils down to individual circumstances.
Right.
And the confirmation from an employer of the work office is important for the purposes of SARS. And if there's any form of dishonesty, fraud there, well, it potentially exposes both the employer and the employer, I would assume, the taxpayer in their personal capacity plus the employer, or would that not be so?
It wouldn't be so. It wouldn't be so unless there's some sort of misrepresentation on the part of the employer in relation to, for example, the duration that the employee spent at home. So really, it comes down the onus of proof in claiming a deduction sits exclusively in this instance with the employee, because it's their individual tax return.
Okay. So would you have any particular tax tips for employees that work from home?
So I would say, definitely ensure that you meet the requirement. Make sure that you meet the 50% requirement. If you can get a letter from your employer, that would be excellent if the employer is willing to provide that. Make sure that you have a home office that is regularly and exclusively used for work purposes. SARS has been quite explicit on the fact that you can't use your dining room table. It has to, in essence, they want an office in your home. Make sure that you keep all your documentation. Extremely important. SARS is auditing a lot of employees, after they claim a deduction. And then also be cognizant of the fact that if you claim a home office expense deduction at the time that you sell your home, if you actually own your home, at the time that you sell it, that portion of your home that constitutes the home office will not be subject to the capital gains tax 2 million exemption that individuals normally get when they sell their home. So there is a disadvantage, and SARS is punting that disadvantage quite heavily to discourage employees from claiming the deduction.
Yes, thank you, Humaira, for giving with one hand and taking with the other, as the receivers known to do. So I certainly didn't know about but in relation to the sale of your residence. That's an important consideration, I guess, for anybody that plays in that space and wants a deduction. So just moving away from the issue of tax for a moment, Apandile, if we can get you into the conversation, the hybrid work environment where employees now work both remotely from home and at the office creates some issues in relation to data protection for companies and employers. We saw POPI coming to full effect last year, so we don't obviously need to get into the details around that. We're all quite familiar with it. But what would you say is an important or significant area relating to data protection that employers must take into account when it comes to this hybrid work environment going forward?
Yeah, thanks for that, Imran, and hi colleagues, and hi to all the participants and clients. So I think a good place to start, Imran, is when you speak of data protection, we all casually say this, and we speak of data protection and we speak of personal information. I think I'll spend just a second to just explain what that actually means. So really, this is an expression really of the right to privacy It pertains to the protection of information about both a living natural person as well as a juristic person. And I pause here for a bit to emphasize this a bit. Reason being that most of the times when people think of personal information, they only think of information that relates to a natural person, individuals such as you and I. But the way PUPI, the Protection of Personal Information Act, defines personal information, which is unique to South Africa, I must add, it relates to both living natural persons such as you and I, as well as juristic persons that are companies, and the protection really applies equally to both these individuals as well as the companies. So I'll pause there for a bit to explain what personal information actually means, and most of the times this is also confused as information that's sensitive, but really the way that personal information is defined in the legislation is really any information that can be used in order to identify a natural person and a juristic person. So it doesn't have to be one's ID number or one's cell phone number. It's really any information that can be used either on its own or in combination with other information for purposes of identifying a person, natural or juristic. Moving on now to the question that you were asking, Imran, which is what aspect of data protection would I like to bring to everybody's attention on the webinar? I think the most important issue is the issue of security, right? And the idea being that what is it that an employer needs to do as employees are increasingly moving to working from home? Now, I think before we start speaking about what it is that an employer can do, we need to first look at what's required by the legislation. So the law says if you're an employer, which you are what's called the responsible party, you are required to implement what's called appropriate, reasonable, technical, and organizational measures, and these must have the effect of preventing loss, unlawful access to data, as well as unauthorized destruction of data. Now, curiously enough, the legislation doesn't tell you exactly what it is that you need to do in order to protect the information. All that it says is you must take into account generally acceptable information security practices, take into account the industry in which you're practicing in, and most importantly, the type of information that you're processing. So depending on the level of sensitivity of the type of information that you're processing, the measures that you do put in place for purposes of protecting that information from unauthorized access, they may differ. Now, when employees are working from the office, naturally, there's security at the gate, there's access control, there's all sorts of protections that are put in place in order to ensure that any information that's being processed by the company is protected. But when employees move outside of those walls, outside of those buildings and working from their home, then there becomes a certain level of risk and some exposure when it comes to the data that they process. And I think the most important thing at this stage is to speak of data breaches, right? So it's a lot harder for any information that's being processed by an employer to be exposed to data breach when it's happening from the office. It can happen, but it's a lot harder because there are measures that have been put in place, and it's easy to prove these in the event that the information regulator comes knocking. But it's a lot different when an employee works from home. There's more exposure, there's likely no security, there's likely no locked doors in order to protect the information that they process. Sometimes employees are working from their counter and everybody has access to their laptops, to the data that they're processing, to the documents that they process, and so on. Now, what can you do as an employer in order to ensure that you implement some reasonable measures for purposes of protecting this information? Now, like I said, the law doesn't specifically tell you what it is that you need to do, but through practice, we've seen some of the measures that employers are implementing, that they put in place in order to ensure that the information that's being processed by employees using sometimes their personal equipment, their personal laptops, and sometimes laptops of their employers, So one of the things that you can do, you can encrypt and install firewalls on all the devices that your employees are using, and employees should be requested to install security patches and update endpoints. You can require security access clearance to company systems such as VPN, restriction system access to specific networks via the device that's being used. You can install remote collaboration safeguards, install licensed security enterprise level conferencing, and collaboration tools such as MS Teams. But
sorry, can I just come in there? So from what I'm gathering, you're saying is with the advent of POPI comes all these obligations, and you're speaking about a lot of practical IT related issues that need to be implemented. Would you say it's fair that old IT policies probably need to be updated in order to give effect to POPI, number one, and to a hybrid work environment in relation to what employees can and cannot do with access to the service remotely?
I think absolutely, Imran. I think absolutely. But I think even before we get to the development and implementation of policies and updating existing policies, I think the most critical thing is actually training. Now, not only is it practical to train your employees as to what it is that they can or cannot not do insofar as data is concerned, it's also critical. It's also a requirement in terms of POPI, in terms of the regulations related to POPI, that employers actually have an obligation to conduct regular internal awareness sessions regarding the provisions of POPI, as well as its regulations. So you have an obligation as an employer to carry out training and conduct training to ensure that your employees know what it is they need to do with information. And then once you've done that, you also have an obligation, which would then be part of the training, to then update your policies, develop new policies where none are in place, and socialize all of those policies throughout the organization to ensure that employees know exactly what it is they need to do insofar as data is concerned.
So perhaps let's round off the conversation, because we are running out of time. Just on a final topic, Pandile. The liability for a company where there is a data breach, or what is that liability? And in your experience, or over the last couple of years, where's the vulnerability been for companies in relation to data breaches?
Yeah, I think the critical important point, Emir, and I think what I want to point out at this stage is what a data breach actually is. So when one thinks of a data breach, they think of this big, leak of information that's been exposed to hundreds and hundreds of people. But the way that it's been defined under the legislation, it's really any unauthorized access to data that you process. Which, if you think about it, and it sounds a little bit ridiculous, if I'm sitting in my office at home and my wife walks in and she picks at a document that I'm working on, that, in terms of the legislation, would constitute data breach. And as soon as that actually happens, that triggers some obligations on you as an employer, as what's called the responsible party, to comply with the law. And as soon as the data breach happens, you are then required to notify that breach to both the information regulator as well as the data subjects, unless you don't have access to those. And one cannot begin to imagine the nightmare that is the admin related to this, the notifications, the press releases, managing perceptions, and reputational damage that attaches to these. And most importantly, if you are found wanting, if the information regulator finds that you didn't do what you were supposed to do, there could be fines that could be issued for your failing to comply with the law. This could go up to 10 million, and there could be some imprisonment as well for those involved in failing to do what they're supposed to do.
Yeah.
So the consequences are dire.
Yeah. So perhaps we should end on that point then, Apandile, before we pass on to the next speaker. I guess what employers need to be cognizant of is a remote work environment does come with risk. Comes with risk in relation to something like data breaches and cybersecurity, whilst it comes with lots of benefits as well. And the question of property compliance is going to become more important as, I don't want to say as the years go by, but as the months go by. And this is going to be no different to ensuring compliance with competition laws, because non-compliance is going to come with serious risks to business. Would that be a fair assessment on that point?
Absolutely, absolutely, Imran. I think most importantly, when the information regulator comes knocking, what they'll want to see is the record of the training that you've provided to your employees and the policies that you've implemented. That's what will save you.
Okay. Well, with that, I'm going to say thank you very much, Apandile. That was very useful. Humaira, thank you for, as usual, with text taking from the left and giving to the right. Some of those points were very useful. And I think the audience, especially in relation to employees who are claiming deductions, need to be alive to those issues. Khudisho, when I see you down the passage later this morning, we'll debate more about vaccine mandates, and as we have another day of battles ahead with employees who are refusing to be vaccinated. Thank you for your input around this. It was very useful. Thank you very much. Ladies and gentlemen, we then going to turn across to Dylan, who's one of our employment associates, who's going to be running through the next segment with us. Thank you very much.
Thanks very much, Imran. I believe, there we go. The slides are there. Thanks so much, Karishka. All right, thank you, everybody. Thank you for having me and welcome to our webinar. My name is Dylan Bushia. As Imran said, I'm an associate in the employment department. Today, I'll be discussing two cases with you with regards to workplace discipline and dismissal. So a slight little deviation away from mandatory vaccination policies, but nevertheless, very interesting and very recent cases that have been issued by the courts. If we could move to the first slide. Right, so the first case that I'll be discussing with you today is the case of Salt Clarke Municipality versus SA Local Government Bargaining Council and others. And this will address the importance of ensuring that charges and charge sheets are drafted carefully and provide adequate information to ascertain what act of misconduct he or she is alleged to have committed. So if we look at the facts briefly, which are important to understand why the Labour Appeal Court came to the decision it did, we have two employees, Mr. Botha and Mr. Fritz. They were carpenters employed by the municipality, and in May 2015, Mr. Calvert, to whom Mr. Botha and Mr. Fritz reported, instructed Mr. Botha, who was the supervisor of a crew, and that included Mr. Fritz and three others as part of his team, to repair a roof, ceilings and eaves at the community hall in Kimberley. And when the supervisor, Mr. Calvert, revisited the site on the same day, he found that Mr. Botha and his crew were dismantling an air conditioner fixed to the roof of the hall. And he stopped and reprimanded them and told them that their conduct could ultimately result in a disciplinary action being taken against them. And so that was the first warning they were given. And later then on the same day, Mr. Butterbos, who is a security official of the municipality, had then found Mr. Botha and his crew with the municipal vehicle. And the parts of the air conditioner which they were warned about had been loaded and taken to the scrapyard. And when he confronted Mr. Botha, he informed Mr. Calvert had given them permission to dismantle this air conditioner and explained that they were busy with a spin. And a spin is a slang term implying that they were making a deal in respect of ill-gotten items. So that's what he informed him there, which of course was untrue. And Mr. Butterbos then reported this to Mr. Calvert, who then came to the scene, and the vehicle together with the parts were taken to the municipality to ensure that they were secured. And so on the Saturday of that same week in May, Mr. Botha, who was accompanied by his crew, they went to the municipal premises where the vehicle was kept and tried to bribe them, which was unsuccessful, following with threats and personal insults, trying to coerce the security guards on duty to give them access to the vehicle and the parts. Of course, they had a plan to sell these parts for money, and the security guard reported this to Mr. Butterbos, and although nothing had been done on that specific day, Mr. Calvert informed him that these parts had been stolen and that they had been kept as a result of a case that was being opened by the police. And so the events of these 2 days resulted in disciplinary action being taken against Mr. Botha and his crew. And at the conclusion of the disciplinary hearing, the presiding officer found that Mr. Botha and his crew were guilty of charged, and dismissal was the only appropriate sanction. But importantly, I just want to summarize the charges, although not trying to overburden this presentation. They were charged on 3 accounts. The first was that they were charged with attempting to sell or selling metal copper pipes and pieces of the air conditioner. The second charge was that they disobeyed a reasonable instruction from Mr. Calvert by not fixing the roofs and opted to rather dismantle the air conditioner. And charge 3 was that they, on the Saturday, entered the premises with the intention to gain entry to get hold of these pieces of the air conditioner. And so they were dismissed on those charges. And so the union then refers the unfair dismissal dispute on their behalf to the bargaining council. Of course, Mr. Botha and Mr. Fritz were not happy with the outcome of their dismissal. Mr. Botha then testified at the CCMA on behalf of Mr. Botha and Mr. Fritz. Of course, he denied everything and gave a very hard to believe version of events. And in his awards, the arbitrator found that Mr. Botha was an evasive and unreliable witness who definitely did not hesitate to make up and adapt his testimony and version to suit his circumstances. Of course, I think many employers have seen this take place before. The arbitrator then rejected the arguments made on behalf of the municipality that Mr. Fritz and his crew members were guilty of derivative or team misconduct, that they colluded in respect of the first charge, which was, of course, selling the air conditioner parts to the scrapyard. And that they were busy with the spin did not amount to the offence of selling these parts in question. The arbitrator found that a mere intent, and of course this is quite important to understand the topic that we're discussing here with regards to specification in your charge sheets, is that it did not amount to a mere intent to sell. A mere intent to sell did not amount to selling. Implying that the respondents could not have then been found guilty of an attempt to sell parts. Of course, the charge was that they had sold the parts, but rather the arbitrator found that they had attempted to sell the parts. So in a strict interpretation, he found that they were not guilty on that charge. According to the arbitrator, because that charge as worded had not been proved, neither Mr. Botha nor any of his crew could be found guilty, therefore, of the misconduct in that charge, let alone any collusion or derivative misconduct. Consequently, the arbitrator found Mr. Botha and Mr. Fritz not guilty on that charge. Then, in respect of charge 2, the arbitrator found that whatever instruction had been given by Mr. Calvert to Mr. Botha was not given to Mr. Fritz, and that it was only Mr. Botha that could have instructed Mr. Fritz. So again, on a strict interpretation, it could not be found that Mr. Fritz had disobeyed the instruction given by Mr. Calvert, and that Mr. Fritz's dismissal for that reason was, and in quotes, baseless and unfair. However, of course, the instruction was given to Mr. Botha, and so he was at least found guilty correctly on charge 2. Finally, on charge 3, the arbitrator found that there was no basis in the evidence for finding Mr. Fritz guilty of this misconduct. Again, the arbitrator, in effect, while it may have been proven that Mr. Botha intended to get hold of those parts to sell to the scrap dealer, there was no evidence that they had actually got hold of those parts and sold them to the scrapyard, and so that part of misconduct had not been proved. And so according to the arbitrator, proof of bare intent on its own did not justify a dismissal of Mr. Botha. Of course, the bare intent in charge 2, he was only found guilty of charge 2, and Mr. Fritz was found not guilty on any of the charges. Of course, the municipality was shocked by this outcome and took the application on review to the Labour Court. That review was set aside. The Labour Court ruled that the arbitrator had not misconceived the nature of the dispute before him and, of course, dismissed the review. Karishka, if we just go into the next slide there. Right. The municipality still not too happy with the outcome of the Labour Court, took it on appeal to the Labour Appeal Court. And in this regard, the Labour Appeal Court had to determine 3 issues. Firstly, whether it could be found reasonably on the evidence led that the charges of misconduct was proved on the part of Mr. Botha and Mr. Fritz. Of course, in this case, Mr. Botha on charges 1 and 3 and Mr. Fritz on charges 1, 2, and 3. The second is whether the misconduct could reasonably have found to have involved dishonesty. And finally, whether the sanction of dismissal was the appropriate remedy in respect of the charges on which they could have reasonably been found guilty. And I think this first point by the Labour Appeal Court is incredibly important for employers when understanding the nature of the charges and the precision in which they have to draft them. And they held that there's no major difference. I mean, there is a difference, sorry, my apologies, a huge difference between the wording of charges in criminal matters than that in charges of disciplinary proceedings, and that an unduly technical approach to the framing of these charges should be avoided. Of course, we look to the recent case law where, you know, they're talking of disciplinary hearings and a decriminalized approach towards them. Disciplinary hearings are not criminal trials, and so the unduly technical approach must be avoided. And the Labour Appeal Court then further held that there's also authority that if the main charge of misconduct is not proved, but an attempt to commit such a misconduct is proved, that the employee may be found guilty of such an attempt on that same charge. So I think that's two crucial elements, and we'll come to the lessons learned for employers just now with regard to that point. But ultimately, the Labour Appeal Court had found that the arbitrator had erred in his interpretation of the charges, and he had obviously seemed to have adopted an overly technical approach in that regard, to have overlooked crucial facts and evidence that led him unreasonably to conclude that the first and second charges had not been proved against the employees. So, of course, taking all the evidence into account, the Labour Appeal Court ruled that the only reasonable inference that had to be drawn from this was that Mr. Botha and his crew intended unlawfully to sell those parts for their own gain at the scrapyard after having removed them. They were, of course, caught in the process of attempting to do so, and they acted in concert and they colluded, and their acts were without authority, and of course, they were also dishonest. So even though they could not have been found guilty of actually selling the parts, as the first charge was worded, they could have been found guilty of attempting to steal and sell the parts for their own gain. And so in respect to the second charge of disobeying a reasonable instruction not to remove the air conditioner, of course, the court found that Mr. Botha was rightly found guilty of misconduct, and that Mr. Fritz could not escape liability on that basis, and that, you know, just because Mr. Botha had not directly instructed him. He was, of course, present when the supervisor gave that instruction, and when he had reprimanded them both. And so Mr. Fritz, they concluded that Mr. Fritz was or must have been aware that Mr. Botha was bound to follow his supervisor's instructions. And so finding Mr. Fritz guilty of this charge was definitely not baseless and unfair. Finally, when we look at charge 3, the Labour Appeal Court found that Mr. Botha's conduct was, as the court says, nefarious and despicable, and there's no reason to accept that the security guard's version of what transpired there. There's no reason to not accept his version in that sense. Finding that, and then what happened then was that the court then looked at the provisions of the disciplinary code that they had referred to in the charge sheet, which was 1.2.3 and 1.2.
Dylan, we're losing you a little bit. Dylan? Imran, we've lost Dylan.
I see that, Karushka. I wonder if we shouldn't then move on to the next.
Sorry, Imran, can you hear me?
Oh, yeah, here we go.
My apologies. Sorry, I just want to wrap up this case. My apologies, disappeared there for a second. So I don't know if you heard the clauses 1.2.3 of the code required all employees to perform their tasks diligently and carefully and to the best of their ability, and clause 1.2.5 required all employees to conduct themselves with honesty and integrity. So ultimately, even though the charges were not specific in that they had attempted to sell, but rather that they had sold, the Labour Appeal Court came to the conclusion that when we look at this as a whole, they had at least breached those provisions of the disciplinary code, that their intent was to sell those parts for personal gain, and that they had broken their trust with the employer, and that they were dishonest, and consequently, and to the municipality's benefit, the appeal was upheld and they were successful. So I guess there are some lessons to be learned from this, Of course, we accept that employers are not expected to be skilled legal practitioners, and they could be excused for formulating disciplinary charges that are too narrow or maybe incorrect. But what's important is that when they draft these charges and implement these charges at a disciplinary hearing, that the employee is not prejudiced. So maybe just a couple of principles in this regard. Firstly, that the employee, of course, this comes from the Schedule 8 of the LRA, that an employee must be aware of the charges against him or her, that the charges must be specific enough for the employee to be able to answer them, that the employer cannot change a charge or add new charges after the commencement of the hearing if it would have a prejudicial effect. But by the same token, the courts and the arbitrators must not adopt a formalistic or technical approach. Of course, it would be sufficient if the employee has adequate information to ascertain what act of misconduct he or she is alleged to have committed, and then the courts have held that the categorization by the employer of the alleged misconduct is of less importance. So again, although we don't need to be drafting extremely precise charges as employers who maybe are not skilled legal practitioners, that it is important to at least make sure that these elements are set out and that they're understood by the employers. I'm going to now hand over to Imran, who's going to chat about the next point. My apologies, I do have to step off, but thank you very much, everybody, for allowing me to speak to you today, and have a great day further. Thank you.
Dylan, thanks very much. I've been asked to speak about avoiding reinstatements. Krushka, are you putting the slides up, or can I do it up on my side?
I can.
Okay, thank you. So in the interest of time, I'm going to talk through this topic quite quickly. But just before doing that, I should mention that earlier in the week, our very fabulous PSL, Amy Kings, had a discussion with her, and I said to her, this was an extremely difficult topic to speak about. How does an employer avoid reinstatement? So I said, perhaps I've got to give a lawyer's response to that, and it would be just don't dismiss anybody unfairly and then call it a day. But this is a difficult topic because we're now at a point that we actually know what Section 193(1) of the LRA is all about. It provides 3 remedies for unfair dismissal. 1 is reinstatement, 2, reemployment to the same or another suitable position, or alternatively compensation. So those are the 3 forms of remedies provided by Section 193. Section 193(2), which we'll see on the next slide, provides that if dismissal is unfair, the arbitrator of the court not may require the employer to reinstate or reemploy the employee. There's an obligation upon an arbitrator to either reinstate or reemploy that person unless 3 things arise. 1, the employee does not want to be reinstated or reemployed, or the circumstances surrounding the dismissal are such that continued employment would be intolerable, or it would not be reasonably practicable to reinstate or reemploy the individual. So that's the benchmark. So where we are now, and turning across to the next slide, is that in October of last year, the Constitutional Court, in the judgment of Boy in Amatori Municipality, now has made it perfectly clear that the concept of reinstatement is the primary remedy. That's what it is. An employee that's unfairly dismissed is entitled to seek reinstatement or to be reemployed, depending on the circumstances, and that is at the election of the employee. So the threshold for intolerability is to avoid it is very difficult. It's high, it's unbearability, and it's not that the relationship is sour or that the relationship would be difficult with the employee going forward, or it would be fraught with some sort of hesitation. That's not the test. Intolerability is also not incompatibility. The employer has a massive threshold to overcome in order to avoid reinstatement where it is found that the dismissal is unfair. So reinstatement is high risk. It also comes with back pay, and we also know from a number of judgments that were handed down by the Labour Court, Labour Appeal Court over the last number of years, that this can well be in excess of 12 months. So an employee that's reinstated 2 years after dismissal can be reinstated with amounts in excess of 12 months of remuneration. Then moving on to what happens in an instance if misconduct is not proven. Now, there was another Afrikaans word I wanted to use, but thought groot probleem would probably say it. You've got massive problems as an employer if the dismissal is found to be unfair, because the arbitrator is not required in law to have regard to the conduct of the employee at arbitration. And this position was made very clear by the Labour Appeal Court in 2018 in Glencoe and Sibeko, that the conduct of the employee at arbitration is not a factor that an arbitrator is to take into account in order to avoid reinstatement in an instance where an employer has failed to prove the misconduct. So the question then is, where does that leave the employer? And it takes me across to the next slide, which raises a couple of points. That preparation of witnesses for arbitration is extremely important. Reinstatement, where an employee seeks a reinstatement, is high risk for an employer. What happens, and this needs to be taken into account in preparation for any particular matter, what if the new incumbent is already in a position? What happens in that instance? What happens in an instance where the position no longer exists? And that's actually probably the easiest situation, because you can't reinstate somebody to a position that doesn't exist, but you can well re-employ because the Act says to a different position. What about the conduct of an employee during the course of the disciplinary proceedings? Not at arbitration, but during the course of the disciplinary proceedings. Can they be taken into account in order to avoid reinstatement? And reinstatement, can an arbitrator make an award after a lengthy period of time? We've seen awards, we've seen judgments of the high courts where reinstatement has been made 7 years after dismissal. So high risk is certainly what it is when an employee seeks reinstatement. Then I'm going to round off with final thoughts that I'll leave you to think about. And it was topics that came to my mind as I was preparing for this presentation. The reality is that an arbitration is one bite at the cherry. That's what it is. So often lawyers get involved, if not at the arbitration stage of a matter or in the internal disciplinary proceedings, get involved at the stage of a review. A review is not an appeal. There's one bite at the cherry. If you can't convince an arbitrator that reinstatement should not be awarded, you're not going to convince the Labour Court of it. It's not an appeal. So one bite at the cherry means proper preparation in order to avoid reinstatement in the first instance. But here's some topics that I think are likely to arise is this concept of the primary remedy of reinstatement now becomes more ingrained as we go forward. Can an employee seek reinstatement and alternatively re-employment, and in the alternative to that, compensation? So effectively, is it a position of, well, tata my chance here? If I don't get reinstatement, I get re-employed. If I don't get re-employed, please, Commissioner, give me compensation. Is that possible? I think it's debatable whether the alternatives in that instance are plausible under the Act. And then finally, there's this issue that I think is going to arise. We know in an unfair labor practice that the successful applicant to the position is entitled to being a party to the unfair labor practice dispute in the CCMA. That doesn't happen because of convenience. It happens because the Supreme Court of Appeal many years ago found that the successful applicant has the right to make representations at arbitration in relation to somebody that believes it constituted an unfair labor practice for them not to have been appointed. But what happens in an instance where there's a new incumbent in a position and the dismissed employee now seeks reinstatement to that position? Is that employee, the new employee, entitled to representations before the CCMA on the question of reinstatement? That issue hasn't arisen. I think it's likely to arise in time to go, in time to come. So at the end of the day, how do you avoid a reinstatement order? The simple answer is with proper preparation in order to make sure that an employee cannot cross the threshold of showing reinstatement is the primary remedy in the particular circumstances of their case. I'll conclude on that point. Thank you, everyone, and then hand over to Buteni Kuna.
Thank you, Imran, and good morning to everyone in attendance. Karishka, could I ask you to please share my slides? Thank you. I am going to be talking briefly on restructuring and retrenchments. Next slide, please. Just a brief survey of key developments that came out in 2020 and 2021. So that is the last 2 years. My first case is SAA in Business Rescue and NUMSA. I'm sure a lot of you are aware of this case, which dealt with, at the time, SAA in Business Rescue. The Business Rescue practitioner had issued a Section 189.3 notice to employees. NUMSA, in this instance, refused to participate in the consultative process, and its position was that the issuing of the Section 189.3 notices had been premature and unlawful, because when that happened, the Business Rescue Plan had not been adopted or published. Now, the Business Rescue practitioner insisted that he had been doing the right thing and should proceed in accordance with the Act to consult with the relevant parties. NUMSA then took the matter to the Labour Court. This came as an urgent application. It sought a declarator, and the specific prayers were that, firstly, the issuing of the Section 189.3 notices had been unlawful. In the alternative, that they had been unfair because they came before the adoption and publication of a business rescue plan. In the second instance, the prayer sought was that the BRP be directed to withdraw the Section 189.3 notices. Finally, that any consultation under the LRA be suspended until the plan had been adopted and published. The Labour Court upheld NUMSA's argument and held that the notices were indeed premature and had been unfair. In the absence of an adopted and published business rescue plan, the employer had not as yet contemplated retrenchments. SAA took the matter, or the judgment of the Labour Court, to the LAC, and the LAC upheld the Labour Court's finding, again confirming that absent the business rescue plan being adopted and published, the business rescue practitioner had acted in haste. Now, another key principle that did come out of this case was that the court said that the business rescue practitioner, whilst cannot issue Section 189.3 notices prior to the adoption and publication of a business rescue plan, the BRP was still entitled to unilaterally offer employees VSPs. And so the parting point or the conclusion is, yes, issuing of Section 189.3 notices cannot happen before a plan has been adopted and published, but the business rescue practitioner which came out of the Constitutional Court. Next slide, please. Now, this case really had to do with whether or not the dismissal of NUMSA's members by Avenge was for the members' refusals to accept revised terms and conditions of employment, or was a dismissal based on Avenge's operational requirements. Briefly, the facts, this comes from way back in 2014 when the steel industry in South Africa was experiencing quite a decline in demand and was just not doing well. Avenge then embarked on a process to restructure its workforce. This would be a twofold approach. Firstly, to reduce its numbers, that is the staff complement, through a VS voluntary retrenchment process. In the second instance, Avenge had envisaged revising or reviewing job descriptions to either get rid of certain functions or to merge certain functions. It then issued Section 189.3 notices and began to consult. In October 2014, NUMSA and Avenged reached an agreement in terms of which the employees would work under the revised or changed job description until such time as the consultative process had been concluded. Shortly after that agreement, NUMSA went back and demanded that its employees revert to the pre-consultation job descriptions. It then also made a demand that their wages be increased. So under the revised job descriptions of functions, Avenge would be compensating them, paying them 60 cents per hour for working in accordance with the revised job descriptions. NUMSA demanded that this be increased to 5 rands an hour. The consultative process ran its course. At the end of it, Avenge proposed or offered the employees new employment contracts, and they would now be working in accordance with new job descriptions / revised functions. They declined this and consequently were dismissed. NUMSA approached the Labour Court claiming that its members had been that dismissals had been automatically unfair. And it was on the basis, as it alleged, that they had refused to accept the employer's demand on a matter of mutual interest, so pertaining to the change in terms and conditions of employment. Avenge, on the other hand, denied this and argued that the dismissals were for reasons related to its operational requirements. So now the court obviously had to grapple with what was the proximate cause of the dismissal. Ultimately, the Labour Court concluded that Avenge's operational requirements and not the employee's refusals to accept the changed terms and conditions of employment were the cause of their dismissals. The matter was the NUMSA then took the judgment on appeal. The LAC upheld the Labour Court's finding, holding that whilst the employees factually did deny or reject the employer's offer to work in terms of revised terms and conditions of employment, their dismissals were as a result of Avenge's operational requirements and not necessarily their refusal. The matter went all the way to the Constitutional Court. We had 3 judgments coming out of there, and essentially all of them confirmed that the proximate or dominant cause of the dismissal was Avenge's operational requirements and not necessarily the members' refusals to work in accordance with changed terms and conditions of employment. However, what is quite key for our clients today coming out of this court, out of the court's decision, was the principle that an employer is entitled to alter terms and conditions of employment as a means to avoid dismissals on the basis of its operational requirements. And where employees reject that, they may be dismissed. So that was accepted by the court, saying that, well, if an employer has to change the functions in the advent or in the face of operational requirements or challenges, and employees unreasonably reject that, then they may be dismissed. The next case deals with I call it the steps in the Section 189 process, whether or not you can consult on one issue before the other. Now, in this case was the discussion around VSPs, that is in the South African Communications Union versus Telkom. This is a Labour Court judgment in 2020. Telkom and SACU had commenced consultation before the first facilitation meeting. SACU, in that consultation, Telkom advised SACU that it intended to issue an invitation to the employees to apply for VSPs. SACU took issue with that and said that the advertising of VSPs before the first facilitation meeting would amount to an evasion or an obstruction of a full consultation. They then, excuse me. Telkom held a different position and instead said that, well, it was amendable to consulting separately with both the minority as well as the majority unions in relation to the VSPs. The minority unions in this instance did not object to the VSPs being embarked upon. At the consultation, Telkom confirmed that it would be continuing with the VSPs, and SACO again raised its objections, saying that Section 189.3 of the LRA prescribed not only the matters for consultation, but the order in which these matters ought to be engaged on. Specifically, the issue of VSPs went to severance, and that is a matter listed in paragraph 5 under section 189.3, paragraph F, sorry, under section 189.3. Telkom therefore could not jump to the VSP discussion without engaging on paragraphs A to G. Telkom held a different view and said that, well, there was nothing that prohibited an engagement or distributing that invite to its employees. The matter went to the Labour Court. The Labour Court held, firstly, that it was paramount that before it intervened, the party seeking or bringing the challenge has to demonstrate that the conduct of the other consulting party has fundamentally prevented or obstructed a fair consultative process. In this instance, the Labour Court went on to consider the arguments raised by both parties and held that essentially the dispute concerned the question of at what stage of the consultative process can the issue of VSPs be brought to the table. The Labour Court then held that the matters for consultation in section 189.3 are not to be embarked upon in a rigid sequence. Therefore, a party, Telkom in this instance, could at that very stage engage or propose VSP. It was not necessarily precluded by section 189.3. The Labour Court also emphasized the importance of not considering the legislation in a piecemeal approach. Specifically stated that section 189.3 and 189.2 ought to be considered together. 189.2 encourages the employer in this instance to try and explore alternatives to retrenchments, and proposing VSPs is one such alternative. Therefore, Telkom was well within its rights and was complying with the LRA when it proposed VSPs. The next case is Lemley and versus the CCMA. This is a 2020 decision of the LSC, essentially dealing with it's not a unique principle, but again reiterating that an employee does not have an absolute right to severance. In this case involving T-Systems, the employee was offered an alternative position in East London, which he refused and did not provide reasons. Now, the employer again reached out to him and this time offered him again the alternative of relocating to East London so as to avoid his retrenchment, and added a bit of a sweetener by increasing his rental subsidy to 4,000 a month for a period of a year, between 6 months and a year. He again rejected the offer and provided no reason, did not engage with the employer. The third time the issue was revisited by the employer proposed an early retirement, which was again rejected. Eventually, T-Systems retrenched Mr. Lemley. He referred a dispute to the CCMA, saying that he had been unfairly dismissed. The CCMA held that his refusal of the offers made by T-Systems as an alternative to avoid his retrenchment were unreasonable. It also criticized how he had not been forthcoming, had not bothered to engage the employer on his reasons for refusing the offers. Mr. Limley then took the matter on review. The Labour Court upheld the CCMA finding, and after that, the matter then went to the LAC. The LAC again confirmed that the employee was not entitled to severance, especially because he had unreasonably refused offers of alternative employment. And then finally, I will be talking about retrenchments and retirement, the matter of Mr. Beria versus Paramount Advanced Holdings. This is an LAC judgment of last year. It's a bit of quite an interesting history. Mr. Beria had been employed by Paramount in 1985 on a permanent basis. And in terms of his employment contract, his employment would terminate at the age of 65, being his retirement age. He turned 65 in June 2013. Now, despite this, the employer did not stop him or pay him his retirement benefits. Instead, he continued to work uninterruptedly until 2017. In 2017, he was offered a fixed-term contract for 2 years, which would end in February 2019. A few months down the line, this was April 2017, he applied for a VSP, which had been offered by Paramount to its employees. He accepted the VSP. Now, the issue that was considered, or the core of this case, came on how to calculate severance and which periods of employment are to be taken into account where there's been a break, or in this instance, the retirement age happened, but the employee continued to work uninterruptedly. Paramount argued that Mr. Beria was entitled to only 4 weeks severance, which was premised on the post-retirement period being 2013 to 2017. He argued on the basis of the Basic Conditions of Employment Act, sections 41 as well as 84, that there had been no break in his service. Therefore, his service had continued. He was entitled to 32 weeks of severance. He added an additional week, which was premised on his VSP agreement. There was then that dispute, and the matter was referred to the CCMA. The CCMA actually agreed with Mr. Beria and said that over and above the 4 weeks that he had been paid, he was entitled to receive an additional 29 weeks. Paramount took the award on review before the Labour Court. The Labour Court agreed essentially with Paramount, holding that his employment had terminated by a fraction of time in June 2013, when he turned 65. The period after June 2013 constituted a new employment relationship, and therefore the employer was entitled to only have regard to the post-retirement age period. Mr. Beria was not entitled to additional severance over and above that. Mr. Beria took the matter on appeal. The LAC considered the definition of continuous service. It essentially held that when Mr. Beria reached his retirement age, he was actually allowed to continue to work uninterruptedly between 2013 and 2017. He therefore had no break in his service. There is the provision in the BCEA which talks about an interruption of service of less than 12 months. Because there had been no break, he was entitled to his 32 weeks of severance, taking into account the period 1985 to 2017. Finally, the court also stated that even if at reaching retirement age he had received his statutory benefits, he had also received his retirement benefits, which in this instance actually did not even happen, those would not have disentitled him to severance. He would have still be entitled to severance because in this instance it was a retrenchment. That concludes my update on the retrenchment and developments in the last 2 years. Thank you, Imran.
Jenny, thank you very much. Very enlightening. The laws around retrenchment are obviously fast developing. Ladies and gentlemen, thank you very much. We apologize, we ran over by 15 minutes. In the interest of time, we're not going to have an opportunity to engage on lots of Q&As. We do apologize. What we will do is try to respond to as many questions as possible. so that we can at least gain this 15 minutes back into our day. Thank you very much. Thanks for taking time out of your busy schedules in early morning in joining us for this discussion. Thank you very much. Have a good day.